for questions to the presenters. So if I could officially just start this morning. So welcome everybody to the national launch by the Department of Employment and Labour of the Asbestos Abatement Regulation. I'm Ashraf Raycliffe, the National Occupational Health and Safety Training Manager for the NIOH, that's the National Institute for Occupational Health, and the NIOH is partnering with the Department of Employment and Labour in hosting this on the Zoom platform. And we are quite pleased as the National Institute for Occupational Health, and therefore on behalf of the Executive Director of the NIOH, as well as the different heads of sections that have played a key role in making all of this possible, and particularly among Ms. Mangani, Jeanette Mangani from the Occupational Hygiene Department, who's currently heading with her team the training for the inspectors of the Inspectorate of the Department of Employment and Labour. So without much ado, I'm going to immediately just to give you a sense of our program, which you have received. First, we'll have the welcoming address by Ms. Maloya, and then we'll have the moving towards an asbestos risk-free society by the Director General, that is Mr. Tobile Lamati. That's followed by the background to the Asbestos Abatement Regulations, presented by Senior Specialist Ms. Bulelwa Huna, and followed by detailed expose of the Asbestos Abatement Regulations as time will allow by Specialist Ms. Elise Lawrence. Asbestos sampling as a very practical aspect is done by my colleague, Mr. Gabriel or Gaby Mizan of the NIOH's Occupational Hygiene section. There will be some time for discussions, keeping in mind that your questions will be typed in the question and answer box, and colleagues will be as panelists as well from the Department of Employment and Labour, as well as my colleague from Occupational Hygiene, would be offering you some sort of answers on the actual platform. So, and then we'll have conclusion by the Chief Inspector, Mr. Tibor Zana. But before we proceed with that, the rest of the program, I'm going to hand over immediately to the Inspector General, that's Ms. Aggie Moilawa. Can I hand over to you, Aggie? If you could just unmute your microphone and your video feed. Thank you very much. I hand over to you.
Thanks. Thank you so much, Ashraf. The video part is my least favorite because these pictures are very unflattering. And when you were introducing me, you tried your best to pronounce my surname. It's actually pronounced Moilwa. I believe that this presents us with an opportunity of telling our stories. It presents us with an opportunity of creating history and influencing the future. The launch presents us with an opportunity to celebrate our breakthroughs and successes. I know that it wasn't an easy task to get to where we are today. It helps us to set in motion things that we have been talking about around issues of asbestos and how to regulate that industry further. It assists us to get underway with things that we continue to grapple with in the asbestos space. It allows us to usher in even new policy directives. So every speaker, I believe, is a pioneer in their own right. And I am looking forward to listening to every single one of them. And I take this opportunity to welcome the DG, my boss, Director General of the Department of Employment and Labour, Mr. Tobile Lamati. I also take this opportunity to welcome all distinguished speakers. Ladies and gentlemen, without you, this wouldn't be possible. And last but certainly not least, I take this opportunity to appreciate our partner, NIOH. And with those few words, I just want to welcome everyone. And I thank you, Program Director. Thanks.
Thank you very much for that, Aggie. I've got this lazy tongue that struggles sometimes over some of the names that I've got to say. My apologies to you. And so, yes, this particular asbestos regulations launch, that is the Asbestos Abatement Regulations 2020. The launch has been put together under the authorization of the Director General of the Department of Employment and Labour. And at this point in time, I have the honor of inviting Mr. Dobile Lamati to share his thoughts and his topic of moving towards an asbestos risk-free society. So, Mr. Lamati, if I could just check if you're, yes, there you are. Your video is visible, and just to check your audio, sir.
Good morning.
Good morning, Mr. Lamati. Well done. I'm not sure if you're sharing any presentation with us, but welcome to your own official launch of the Asbestos Abatement Regulations. And thank you very much from the NIOH for the opportunity to partner with you. Please proceed.
Thank you very much. Unfortunately, I will not be sharing a presentation, but I want to greet everybody, especially the NIOH for partnering with us, the Inspector General of the Department of Employment and Labor, all the representatives that are a part of this from our social partners, all our guests, clients that are part of this event, and the inspectors of the department that are also part of this event, and everybody. Just good morning, and I hope that you are surviving the difficult time that we find ourselves in. Thank you for joining us today to officially launch the Asbestos Abatement Regulation that were promulgated on the 10th of November 2020 by the Minister of Employment and Labour. Unfortunately, South Africa has a long and tragic history with asbestos. Just to go back to the archives, to the history, in 1906, the first death related to asbestos was documented. In the early 1900s, researchers began to notice a large number of people with lung problems and early deaths in towns that mine asbestos. In the global scene, the first diagnosis of asbestosis was made in the UK in 1924. In the 1930s, the UK regulated ventilation and made asbestosis an excusable occupational disease, effectively underplaying the impact of the disease. You can actually say that we've come a long way. The term mesothelioma was first used in medical literature in 1931, and its association with asbestos was noted in the 1940s. Many multinational companies worked in South Africa, contributing to the current plight of asbestos in our country. One of such companies was Cape PLC, which was founded in 1893 in Britain as the Cape Asbestos Company, with the objective of mining asbestos in South Africa and importing it into European countries where it would be woven into fire-resistant materials. By 1913, it had 4 factories in the London area. Cape PLC was involved in mining crocidolite, which is a blue asbestos, and amosite, which is a brown one, in the Northern Cape and Limpopo until 1979. In addition to mining, mills were established to crush the asbestos rock to expose the fibers. This led to the environmental contamination in many towns in those provinces. The asbestos products from asbestos mined in SA were not only manufactured locally, but in Italy and England as well. These were then sold around the world. This practice led to the exposure of miners, factory workers, sheepdog workers, and communities to asbestos. Claims for compensation against KPLC were made by American asbestos victims, as well as Italian workers employed by KPLC subsidiary. In 1999, almost 2,000 claims were proceeded with in England against KPLC by South African claimants exposed to asbestos in South Africa during mining and other related activities. By 2001, a total of 7,500 claims were registered. There were 75% of the claims from Limpopo and 25% from Northern Cape. In 2001, there was a settlement that resulted in the payment of £21 million into the Hendrik Africa Trust. In March 2003, 3 new settlement arrangements were signed by the new owners. Thereafter, the company was unbundled. This is an illustration of the painful and tragic history as a result of undue exposure of victims to asbestosis. The compensation that was made to the next of kin of the victims was small relief against the loss of life. In 2008, South Africa joined 50 other countries in banning the use, processing, and manufacturing of products using asbestos. In the same year, the then Department of Environmental Affairs promulgated the regulations prohibiting the use, manufacturing, importing, and exporting of asbestos and materials containing that asbestos. This was carried out under the Environmental Conservation Act and Act 73 of 1989. In 2007, an extensive study was undertaken by government to assess the extent of secondary asbestos contamination, especially in previous asbestos mining areas. The study revealed that the provinces that showed asbestos contamination from environmental sources were the Northern Cape, Limpopo, Northwestern Mpumalanga. Under the Department of Environment, Fisheries and Forestry, the waste management strategy in terms of NEMA currently requires the reuse and recycle of all waste. However, if asbestos is to be reused or recycled, this would just transfer the problem and the health risk. Therefore, disposal in landfill is the only viable option when coming to management of asbestos waste. To facilitate the management of asbestos that is contaminated with secondary asbestos due to mining and other activities, a national secondary remediation plan was developed in 2009. This plan aimed to remediate areas that were identified and to facilitate integration and sustainable management of asbestos in the country. The strategy objectives, amongst others, represent the following specific areas in which focus will be placed. 1, to promote sustainable management of asbestos. 2, to facilitate collaboration among key role players. 3, to develop intergovernmental industry forum on asbestos management. To mobilize research institutions to investigate best practices for sustainable management of asbestos. To facilitate advocacy, education, consultation on asbestos and related community and health issues. To implement a risk-based approach on asbestos management. To create a platform to exchange information on best practices on asbestos management. To supplement existing approaches on the management of asbestos in order to strengthen asbestos management systems in the country. The World Health Organization, joined by the International Labour Organization and the United Nations Environment Programme, has called on countries throughout the world to eliminate asbestos-related diseases. The World Health Organization advises that the best way to eliminate such diseases is to stop using all types of asbestos. I am pleased that South Africa has now terminated the use of asbestos. The use of asbestos has declined by 55% from its historical peak of 4.7 million metric tons per year in 1980. However, more than 2 million metric tons per annum are still used worldwide. As is the case with many other countries, South Africa still has asbestos-containing materials in many buildings and naturally occurring asbestos in areas where it was previously mined. The legislature has already developed appropriate legislation and policy. However, the prime focus is to manage and control asbestos sources, thus ensuring that the health of workers and communities in general is not affected. And that is why today we are launching these asbestos abatement regulations. And I want to take this opportunity to thank all of you for being part of this process. I thank you, Program Director.
Thank you very much. That was the Director General, Mr. Dobile Lamati of the Department of Employment and Labour, and I'm pleased to have had Mr. Lamati, the most senior official of the Department of Employment and Labour, that is participating in this launch of the Asbestos Abatement Regulations. I've also just placed in the chat box the link to the newly published and promulgated Asbestos Abatement Regulations, and you will see it in the chat box. I will repeat it from time to time for you to download it. I'm hoping that all of you that's part of this particular webinar, and we're already over 600 people, that you have your copy of the abatement regulation with you already. Our next speaker on the topic of the background to the Asbestos Abatement Regulations is Senior Specialist, Ms. Bulelwa Huna. Good morning, Ms. Huna. Can we just check if you could share your video and audio and your presentation? And then as a bit of admin, please, a reminder that any questions you have, you may type in the question and answer box. That's the question and answer window at the bottom with the two little bubbles. And then for general comments, that'll be in the chat box. That's where I, for example, also place the link to download the regulations. Thank you, Ms. Huna. I see your slides. If you could maximize it and just check your audio and your microphone. Bulelwa, you may have to unmute, is my assumption.
Can you hear me now, Ashraf?
There you go. Thank you very much.
Okay,
There's a few moments of worry on my side, and you've just helped me there.
No, there's a delay on my side. I've put the screen on slideshow. Is it indicating on slideshow?
Your slideshow is here, but if you do have a connection issue, then we can also share the slides from our side. We'll monitor that in a moment. If you could maximize your slide, at the moment it is not yet maximized.
Then it's best if you share from your side because it's maximized on my side. I will unshare the screen then.
Okay, thank you. I'm going to ask my colleague Ola, the manager of our IT department, just to please share Ms. Bulelwa's presentation from your side. In the meantime, for those who are attending, we could make available a certificate of attendance in discussion with our colleagues at the Department of Employment Labour. For this particular session, there are no CPD points that has been assigned for this. And a reminder, please type your question and answers in the question and answer window, as well as your general comments in the chat window. So I have Tumela asking in the question and answer box about presentations. That's a general comment. And then there is one question already from Anonymous, etc., as well as from Werner Mini. And we will get to those questions. I'm going to encourage our presenters and panelists to keep on monitoring the question and answer box. Thank you very much for that, Ola. Bulelwa, can you see your slides?
Yes, I can see the slides.
Yeah, please just say next, Ola, and he'll move your slide for you. Please proceed. Thank you.
Okay. Thanks, Ashraf, and welcome to all participants. And thanks to the DG for such a great opening. He has actually set this launch at a high bar. So we will be talking now about the background, the journey that we took for us to come to this day, and also indicate now some of the principles that are linked to the Asbestos Abatement Regulations as South Africa is part of the international community. Next slide. Next slide, Ola. Okay, as we are part of the global community, annually across the globe, there are about 270 million occupational accidents and about 160 million occupational diseases. And this includes diseases related to asbestos exposure, but that 160 million is an underplay because there's a lot of underreporting when it comes to occupational diseases. As we heard from the DG, the first disease was diagnosed early in the 1900s. According to the ILO, about 4% of the world's gross domestic product is lost due to accidents and work-related diseases. And these are issues that are preventable in the workplace, meaning that that money could have been used for preventive measures. Aside from these economic costs, they cause immeasurable human suffering, and also there is intangible cost that is not fully recognized, whereby the community suffers because of exposure to such accidents and diseases. Next slide. When we look at the economic costs of poor occupational health and safety practices, they affect two parties. We've got the employer on the other hand, and we've got the employee. And then we can bring a third party, that is the community, when it comes to asbestos issues. When it comes to the employer, there are medical and rehabilitation costs. And when it comes to the employee, there's loss of income, because that employee, if he's in one of the variable sectors and not working for the public sector or an affluent company, the person may depend now on UIF for illness benefits, or have the benefit from the compensation fund. But now, there is also the social security system that now will be impacted by this. And then if we look at the community that is in areas where there is a lot of asbestos, those community members, they suffer because of that. So in this aspect, we can bring in a third aspect. So as regulators across the world, and us in South Africa, we have never accepted the proposition that injury and disease go with the job. We are concerned with the quality of life of the persons. Next slide. When we look at health and safety at work, we need to remember that it is key to sustainable development and investment. And such an investment in OHS can help to contribute to the achievement of Agenda 2030. Hence, in South Africa, we've also promulgated the Asbestos Abatement Regulations, because now, as the country, as we've got a national plan, when it comes to asbestos elimination, we need to move in one direction. Once the keyword in these regulations is abatement. Looking at the Agenda 2030, looking at SDG 3, it looks at ensuring healthy lives and promote well-being for all at all ages. So this is a concern. This SDG affects the people that are living in such communities. So as government, how do we work together to make sure that such communities are protected from these practices? Looking at SDG 8, it talks to promotion of an inclusive and sustainable economic growth, employment, and decent work for all. And in particular, Target 8.8 talks to protection of labor rights and promotion of safe and secure working environments for all workers. And this will include migrant workers, in particular, women migrants who are in precarious employment. As we know, when asbestos were being mined in South Africa, we had people that were from the SADC region that were migrant laborers that were working in South Africa. Now they've migrated back to their homes, and now there's a burden of disease in those countries. So it's not only affecting South Africa. Next slide. So those are that SDG 3, that is green in color highlighted there, is the one that I've just spoken to, talking to the good and well-being. So these regulations are contributing to that. And also SDG 8, they're circled the red block, talking to decent growth, work and economic growth. These regulations are also supporting that, making sure that the country, through the National Development Plan, we are able to contribute to the outcomes that the president needs to respond to. Next slide. As we are part of the global community, there are international instruments that we have to make sure that when we develop regulations or legislation, we respond and align to such international instruments. So when we look at the international labor standards, the core values reflected in these ILO standards on occupational safety and health, they are expressed in three main principles. The first one talks to work that should take place in a safe and healthy working environment. And that is the key component of our OHS legislation, looking at both on Section 8, whereby the duty and onus to ensure such environment is placed on the employer. Also linking to the asbestos abatement regulations, the employer still needs to carry such a duty to make sure that when working with asbestos containing material, that work should take place in a safe and healthy working environment. The second principle talks to conditions of work that should be consistent with workers' well-being and human dignity. When there was the international conference last year in Geneva in June, health and safety was recognized as a fundamental human right. So that principle, talking to conditions of work that should be consistent with workers' well-being and human dignity, is very important, because health and safety is a fundamental right. So people working with such with products containing asbestos containing material, their well-being and dignity needs to be well preserved. The third one talks to work that should offer real possibilities for personal achievement, self-fulfillment, and service to society. So as workers, as a worker or an employee, you sell the labor to the employer, and then whatever you get on month end or at the end of the week, you plow back to the community through the shopping that you'll be doing, putting it in layman terms, and you're supporting your family. So that is a service back to the society. Next slide. So the DG has already indicated why we needed, as the Department of Employment and Labor, to promulgate the Asbestos Abatement Regulations. As he already indicated, the World Health Organization, in collaboration with the ILO and other intergovernmental organizations, civil societies, work with countries towards elimination of asbestos-related diseases. And as South Africa, we are participating in that. As South Africa forms part of this drive, these regulations aim to move away from asbestos in workplaces and communities, and move away from the health risks associated with asbestos exposure. So we have to make sure that through these regulations, we take the steps to make sure that we leave a good legacy for the future generations. The Asbestos Abatement Regulations are promulgated in terms of Section 43 of the Occupational Health and Safety Act, number 85 of 1993, as amended. And that is the power held that has been given to the minister. Next slide. So in terms of the OHS Act, that is the main purpose, and all regulations linked to that. Because in terms of this act, it provides for the health and safety of persons at work. So the health and safety of persons working with asbestos and asbestos containing material needs the employer needs to make sure that such people are protected. It also provides for the health and safety of persons in connection with the use of plant equipment and machinery. So people in such environments, the employer needs to make sure that they achieve the purpose of the act. The purpose of the act also looks to persons other than persons at work that may be affected by the activities of that particular employer. So the communities whereby should it be maybe asbestos removal or maintenance, or maybe now the community needs to be rehabilitated. This act also looks into that. And then also, it also provides for the establishment of the Advisory Council on Occupational Health and Safety Matters and for matters connected therewith. That is the council now that advises the minister, which gave the go-ahead for the development of these regulations. Next slide. So when we look at the duties of the employer, which have also been also the principle brought to the Asbestos Abatement Regulations, this duty links to one of the core principles of the ILO, whereby the employer has to provide and maintain, as far as is reasonably practicable, a working environment that is safe and without risk to the health of employees. So we can already see that this links back now to that first core principle. So the employers have a responsibility to protect employees against these health hazards when working with asbestos and asbestos-containing material. There is a clear duty on employers in the new regulations to identify asbestos in place and also manage it properly. Next slide. Also, when we go to section 14 of the Act, the employees also have a duty. They have to take care of their own health and safety and also look after others who may be affected by acts or omissions. They must cooperate with the employer to enable that employer to comply with the Act. They must carry out any lawful instructions and obey such instructions in the interest of health and safety, because this is to make sure that their well-being and human dignity is preserved. So they have also a duty, because rights, they come with responsibilities. Hence, they've got this duty that they must take care of themselves. Also, they should report any unsafe situations to the employer or the health and safety rep. And this principle has been carried across in the Asbestos Abatement Regulations, whereby the duties of the exposed are clearly spelled out. Next slide. So when we look at impact of legislation, we see that diagram, that triangle in the corner there, there's social dialogue at the center in red. We've got government, organized business, and organized labor. So when we develop a legislation, it is a direct result of collaborative work, which encourages tripartite social dialogue, because the product that is being presented in front of you today is a product of social dialogue. There were intense deliberations in that technical committee. And then also legislation promotes collective bargaining, effective health and safety programs in place, which are going to be key now for the abatement of asbestos in the country. And also they support effective labor inspections, because our inspectors are going to play a key role in ensuring that employers put systems in place to make sure that they address issues that are enunciated in the Asbestos Abatement Regulations. Next slide. So as already indicated, when we develop a legislation, we have a tripartite structure, but when you look at that pot, there are 4 parties in play. So this is a tripartite plus structure, because we've got government. In this context, it was Department of Employment and Labor that was leading the process. Then we had organized business that represented businesses. Then we had organized labor representing all the federations that participated here. Then we've got specialists in the field, because this is a highly technical field. So the 3 parties cannot do it together. Hence, we've got a 4th component in that pot. So in the TC, we had occupational medicine specialists, because there are medical issues that need to be addressed. Then we had hygienists, because they're the ones now that will be conducting monitoring when it comes to asbestos exposure in the workplace. And then we also had other parties specialized in different aspects of asbestos, who also contributed to the development of these regulations. Hence, we've got this product today. So this required effective collaboration and cooperation amongst the parties, because you know, when great minds meet, there's a lot of debate that takes place, but at the end, you must have a product that is a product of consultation. Next slide. So that is a process that we followed. Developing legislation is a tedious process, because you have to cross all your T's and dot all your I's. So you do not just wake up in the morning and decide that I need to amend this legislation, or I need to review that particular legislation. You must, as the leader of that particular project, develop a business case and have an initial socio-economic impact assessment process that takes place to prove that there is a need now to review or establish this particular regulation. And then this gets presented to the Minister's Advisory Council on Occupational Health and Safety. Then they will grant approval for the establishment of that technical committee to work on that particular regulation. Then the review process or drafting process will take place, and that has to be presented back to AIAs, who will advise the minister to approve for the public comment phase. That's where now the public is allowed now to comment, and the period is 90 days. And we're almost the only department that allows 90 days. Allow others, they give about 30 days for public comment. So we go through an extensive public comment phase, whereby we also do road shows to make sure that we take people through the regulation, so that when they comment with an informed mind. So after the closure of the public comment phase, then the TCCs again consolidate and consider the inputs that have been received from the public. And this also now goes through debates and everything, whereby they have to check each and every comment, record it, and make sure that they deliberate on those particular comments and check now whether these are adding value now to what needs to be achieved by the regulations. And then this gets submitted to AIAs again, because they have to relook at it. So once they give a go ahead, now we know that we've got our supreme law in the country, the Constitution of the Republic of South Africa. We have to take now this draft regulation to the state law advisors, whereby they have to check now on constitutional validity of that particular piece of legislation. So if they are happy with that legislation, they will give a certificate that certifying that that piece of legislation or regulation is constitutionally valid. So this regulation has also gone through that process. And then it will go for language editing through the Language Bureau of South Africa. And this is important because all the people that are in these committees, English is not their first language. So we need a specialist now that will look into that regulation and make sure that the correct language has been used. Then after all this, we follow again the socio-economic impact assessment process, which is the last phase, whereby I have to prove now we have thoroughly consulted with the public. Then once the certificates, the CS certificate is received, the final draft is submitted to AIAs, and the minister now will be advised by AIAs to promulgate the regulation. Hence, we are launching the Asbestos Abatement Regulations today. We can see this was really a tedious process. And next slide. Previous. No. After this one. Yes, on this one. So as the theme of this launch is moving towards an asbestos risk-free work environment and society, as the DG has already indicated, there is a national plan to eliminate the risk of asbestos. So looking at this plan, it has already indicated, it should establish the magnitude of the problem in the country, highlighting the most important figures from the national asbestos profile, and this should include the summary of the national inventory. Past and current issues must be part of that inventory. Also, there must be the development of an inventory that can be prepared using customs information and domestic data on industrial products, so that we know what is it that we have on our country. And also, this plan should address the number of exposed workers and the levels of exposure. So that's why the approved inspection authorities are very important, because these are the people that conduct the monitoring and indicate on the exposures, because we need to know which are the high risk groups, which industries and occupations have to be clearly defined. And this data can only be obtained when we get the monitoring results. Lucky for us, we already have a requirement for approved inspection authorities to report twice a year. So based on these regulations, we'll be receiving more data because we've got more checks and balances in place. Next slide. Also, this plan needs to estimate the future burden of the disease attributable to current and past asbestos exposure to determine potential health impacts than actual incidence and prevalence of reported asbestos-related diseases. Because this problem started with mining, and some of the people that were in the mining community, they were migrant laborers within South Africa and outside South Africa. And some of these migrant laborers were coming to the Eastern Cape in areas from the former Transkei, former Ciskei, and such people went back home, and they can realize that they've got respiratory problems, but some of them are unable to link back to what they were exposed to at work. So this national plan is key in looking into such issues so that a track and trace system can be in place to make sure that such issues get addressed. Next slide. Also, this plan needs to look at strategic economic arguments for eliminating asbestos-related diseases. So there are direct costs that are in place. So we can look at that iceberg effect. So the direct cost, looking at the tip of the iceberg that is outside the water, is the treatment costs and compensation. Because such people, they need to undergo treatment and they need to be compensated. Because others might be needing oxygen to assist them with breathing and so forth, and also other things as determined by the treatment plan that will be in place. Also, the cost for demolition of buildings containing asbestos, that is also a direct cost. So that becomes important now where the contractor gets a tender, because the contractor needs to make sure that they abide by these regulations, because there are checks and balances in place. So now it must not go now to an issue now whereby on the tender, it's only now issues that exclude health and safety that are checked. So in the tender document that gets advertised, health and safety that supports elimination of asbestos needs to be key, because that will form part of the cost for that tender. Next slide. And then when it comes to the indirect costs, we can look below the water now, whereby we don't see the iceberg. There's lots of potential income from asbestos containing tourist facilities, because now if these facilities have gone fibers that are exposed and the building was not maintained, it's going to become a health risk. So the tourism industry may lose such income. So this plan needs to look at such, so that if they need now to look after those buildings, they also look into these regulations, what are the requirements? And also the depreciation of house stock built with asbestos also is in place, because in the olden days, the roof sheets were containing asbestos material, and the Department of Environmental Affairs is looking to such with human settlement, are looking to such projects now in the different provinces. Next slide. Lastly, the social aspects are key. They need to be included in the program, because remember, one of the other principles we spoke to is well-being and human dignity. Therefore, social justice and equity aspects should also be tackled in this plan, because living with asbestos has put some communities in a position of social disadvantage. A few years back, we had some cases in Northern Cape whereby teachers were suffering from mesothelioma, and yet they are not working with asbestos, because in those communities, because of mining and asbestos that is naturally occurring, by the mere fact that the children are playing in the play fields, they're exposed to asbestos, and the teachers are there the whole day, and the school, the material that is there, that had built the school, is containing asbestos. So social aspects are key for this national plan, so that such communities are looked after. Next slide. So So the theme of this launch, as the DG has mentioned, is key in ensuring that the right that is entrenched in the Bill of Rights is observed. We know that we've got the supreme law of our country, and this is the all-encompassing statute in South Africa. So when we look at Section 24 of the Constitution, it sets out the right to an environment that is not harmful to health or well-being. And it calls on the government to take legislative and other actions to prevent pollution and ecological degradation, promote conservation, secure ecologically sustainable development, use natural resources while promoting justifiable economic and social development. We know that asbestos is a natural resource, but it's a natural resource now that negatively affects their health and well-being. Next slide. Therefore, addressing the current and expected social impacts of the use of asbestos and asbestos-containing materials needs to be taken into account to ensure a just transition during the conversion to non-asbestos substitutes and technologies. So that just transition is very important. The data presented should look on the number of jobs related to the import and domestic production of asbestos and asbestos-containing material, specific social networks and communities which are dependent on the consumption of asbestos. Next. With all this in mind, the Department of Employment and Labor embarked on the development of the Asbestos Abatement Regulations in order to move towards an asbestos risk-free work environment and improve the quality of life for all. Next slide. So with these regulations, if you look there, we've got two diagrams. The other one, if you look at the center, we've got the diagram without the preventive component. So we can take we can go back to when the country was working with asbestos. So we're not having an actual preventive component when it comes to asbestos, whereby industry, we have a healthy person that entered the workplace, and then got an industry that worked with asbestos and asbestos-containing material. And then people got the disease. Now there was diagnosis. Now there's treatment and care for those that were affected and afflicted. So if we move to the next diagrams, with these regulations, we are entrenching the preventive component because we want to make sure that for those who are not yet diagnosed with asbestos-related diseases, we maintain their health and well-being whilst looking after those who have already been diagnosed. So these regulations are key to such. Next slide. So with the preventive component, we are also ensuring that it promotes and supports our economic growth, because now if we have a reduction of occupational diseases that are linked to asbestos-related work, we are looking at an improved quality of life, because we know that as workers, we sell our labor to the employer. So if the employer is looking after you as the worker or employee, you feel protected and it improves the quality of life. You give more to the employer, and it also promotes productivity, which has got a positive spin-off on the economy. And also through these regulations that introduce the preventive component, it also improves the community well-being as well as relations, because now with preventive components, also looking after communities in collaboration with our government, other government departments, it's gonna decrease the risk of having unrest communities due to such problems that have been introduced by asbestos, because we'll be working together to bringing a solution to making sure that it also promotes our economy. Thank you.
Thank you very much. That was Ms. Bulel Wahuna, who is the senior specialist. And thank you very much for sharing that perspective on this particular regulations and the importance thereof. We do have quite significant time on our hands, and which could possibly assist also with some general discussions at the end. So our next presenter that will be dealing with the Asbestos Abatement Regulations itself, and I'm going to allow Ms. Lawrence, that is Ms. Elise Lawrence, lots of leeway and latitude with regard to the time she requires, because we are quite significantly ahead of time at this point in time. So I now have the pleasure of inviting Ms. Elise Lawrence, the specialist within the Department of Employment and Labour, who's going to specifically deal with the regulations itself. And my many thanks to her for her liaison on the part of the head office of the Department of Employment and Labour in putting all of this together. So I immediately hand over to you, Elise. If you could just maximize your slides, that will be great. And just to check your audio with you.
Thank you, Ashraf.
Thank you very much. Go ahead, please.
Right. Thank you so much. And thank you, everybody, for joining us this morning. We really appreciate the numbers that we are seeing. And thank you very much to the Director General, the Inspector General, the Chief Inspector who's going to be speaking later, as well as Bulewa for a presentation. It's nice to feel supported in this endeavor. And thank you also for the extra time. I'm sure that I will be needing it going through the presentation, because my presentation is basically just a reflection, true reflection of the regulation. So you'll see there's quite a couple of slides in this presentation. So let's get into it. So this is the contents of the presentation as well as the regulation. And you will see it's quite lengthy. Even the contents is 4 pages long. Those of you who had an opportunity to look at the regulations when it was promulgated earlier this month would have probably looked at it with an eye of finding the things that have changed from the old regulation. And if you did that, you will probably realize that almost everything has changed. There's very little that remains the same as previously. So that implies that all of us will have
Elise, apologies for the interruption. There's a few comments on the chat box where people are saying they can't see the slides. So if you could just maybe redo that. Maybe just unshare and reshare, because I still have your slide on the pre-large screen. My apologies for doing this, Elise.
No, that's fine. We're sorting out quickly. Thank you.
That's perfect. Thank you very much. It's on the contents number 24 to 27 slide at the moment. Please proceed. Yeah. Thank you.
Thank you. That's exactly where I am as well. Okay, so as I was saying, we're all going to have to do things differently from the way we've been doing it for the last 90 years. And I think from the previous presentations, you would all be convinced as to why that is needed. We can't continue as we were. We need to start moving away from asbestos. And although that is a simple statement, because it's so widely spread and in so many forms, this is not a straightforward and easy task. But we need to start taking the first steps. And these are the first steps in getting us away from the health risk that asbestos is posing. Sorry, I'm just having trouble now moving my slides. We're just trying to sort that out.
Okay, just a quick admin announcement while that is being addressed by Elise and Ola. Please do not raise your hands in the chat or the question answer box, please. We cannot accommodate raised hands in this particular forum because our numbers are just way too much. We'll see potentially towards the end if there could be an accommodation. So are you okay, Elise? Can I hand over?
Yes, seems like
Thank you.
Up and running again. Thank you.
Please.
So basically in the past couple of years, the majority of the work that we were doing relating to asbestos was with relating to demolition. And you would have noticed now that there's a big shift from that in this new regulation. So in a nutshell, what we are saying is that asbestos demolition is not allowed anymore. So, and we have adopted the definition of demolition from the construction regulation. So what that means is if a building needs to be demolished, the asbestos materials in that building needs to be safely removed before demolition may start. So this is a big shift in operations as well as in how we then deal with asbestos and the terminology that we use. So you will also have noticed that there are a lot of new definitions in the regulation, and I'm not going to spend time going through each of those regulations, but I would suggest that you take the time and find the definitions, find the new definitions, in order for us all to talk about the same thing when we talk about asbestos and the terminology used in the regulation. So the first definitions, the ones that I am going to spend some time on, is just 3 definitions dealing with the types of asbestos work. So type 1 asbestos work deals with small quantities. And you will see all 3 of these definitions specifically deals with a specific type of asbestos product, as well as what can be done with that or to that asbestos product. And type 1 then also limits the quantity, the size of the material that can be dealt with. So type 1 asbestos work is the painting of asbestos cement products, and there is a definition for asbestos cement products, in a manner that does not require surface preparation. Now there's already been some excitement about this statement, but it's very clear and very simple, and the technical committee and AIAs felt that this is the right way to go, because during surface preparation is when the fibers get released, and that is what we don't want. The painting of the asbestos cement product is not the problem. It's the surface preparation beforehand, the cleaning, the scrubbing, the brushing of it. So that is not allowed. So if you cannot just take a paintbrush and start painting a piece of asbestos cement product, you cannot do it. If you need to do surface preparation beforehand, that is not allowed anymore. Also, type 1 work allows for the removal of less than 10 square meters of asbestos cement product. So this is just a simple removal intact. A large roof sheet will fit into this size parameters. But another limitation here is that this kind of work may not be repeated within a period of 6 months. So therefore, the person doing the type 1 asbestos work cannot repeat that kind of asbestos work before the lapse of another 6 months, as well as a specific site, also a site where type 1 work is being done. It cannot be repeated within 6 months again. This is to limit the possible exposure to the fibers to as low as possible. If we exceed these limitations of size, of product, of time, then the risk is not negligible anymore. And then we might expose people to this dangerous substance, and that is exactly what we're trying to prevent. Also, for type 1 asbestos work, registration is not required with the Chief Inspector of the Department of Employment and Labour. Then moving on to type 2 asbestos work, and this is the type of work that we expect will happen mostly in South Africa. This is the repair, encapsulation or painting of asbestos cement products in a manner that does not require surface preparation. Once again, the surface preparation is where we have a problem. This is where the fibers get released, and we do not want that. Also, then type 2 work allows for the removal of asbestos main products or asbestos installation work. Once again, there is definitions for these terms: asbestos main product and asbestos installation board. Then type 2 work requires registration with the chief inspector. Type 3, this is the dangerous stuff. This is where we are dealing with asbestos coating, raw asbestos, and asbestos fibers, the actual fibers themselves. So type 3 work then allows for the removal, repair, or encapsulation of these materials, and this requires registration with the chief inspector. There's going to be some of the slides that I'm just quickly going to jump over for the sake of time so that I can spend more time on the more pertinent topics. So the scope of application is straightforward. There shouldn't be any issues around that. Then the first major jumping in regulation is then the identification of asbestos in place. So there's an expectation that for the employer or self-employed person to, as far as reasonably practical, ensure that all asbestos containing materials at the workplace are identified by a competent person. Now, this is not a new thing. This was also in the old regulation, and people shouldn't be surprised in seeing that. It's just that, yeah, there's a lot more focus on it now. The competent person, you will see that competent persons are referred to several times throughout the regulations, and the definition for competent person is general enough to allow for all of these different competencies. So for instance, the person who is competent to identify asbestos in place might not be the same competent person who is competent to provide training. So for asbestos in place, if uncertain whether or not the suspected asbestos material is, as a matter of fact, asbestos, then there is two options: either deem the material to be asbestos containing and treat it as such, or arrange for a sample of the material to be analyzed for lab confirmation whether or not this material actually contains asbestos. If part of the workplace is inaccessible, we might be talking here about seating voids or areas like that where nobody can actually get in to see whether or not, or take a sample to confirm whether or not there is asbestos, then it must be assumed that asbestos is present there, and this area should then be included in the inventory of asbestos, and this area should then be identified as asbestos in place. If no asbestos is in place is identified, ensure that the asbestos-free status of the workplace is substantiated in writing by a competent person. So we foresee that buildings that were probably built after 2008, 2009, very unlikely contained asbestos. But buildings older than that, we need verification whether or not there needs to be an inventory of asbestos in place. If an employer or self-employed must obtain the service of a competent person to ensure that all material identified or is assumed to be asbestos-containing material are entered into the inventory of asbestos in place, which is kept at that workplace. So this is now up to each company, especially for big companies, to decide where this inventory of asbestos in place will be useful. It will serve very little purpose if the inventory of asbestos in place is kept at head office and maintenance work needs to be done on site, and there is no inventory for everybody to know exactly where the asbestos is. So this is a practical arrangement that each company would have to make sure that the inventories are available where they are needed. With regards to any disagreement whether or not any substance is in fact asbestos, the Health and Safety Committee or person nominated by the employees may require that a sample be taken to definitively identify whether or not asbestos is contained in that material. The inventory of asbestos in place must contain the following information: the date when this material was identified, a description of the material, for instance, a roof sheet or a ceiling board, the quantity and the extent of the deterioration. So on the inventory, it should be indicated whether or not this piece of material was well maintained throughout and is still intact. The location, as on a detailed floor plan, the confirmation of the labeling, and we'll deal with labeling and signage later in the regulation, the risk categorization to indicate whether this is a piece of material that is considered high risk or is it intact and the risk is low, a description of the potential exposure scenarios. An employer must also ensure that a competent person reviews and, if necessary, revises the inventory of asbestos in place at intervals not exceeding 12 months. So if the employer develops this inventory himself, it must be reviewed by a competent person at these intervals. The inventory of asbestos supply should be reviewed more frequently if further asbestos containing material are discovered, and if any of the asbestos containing material deteriorates or is removed, damaged, or coated during maintenance procedures. Where the asbestos removal or repair of asbestos containing materials are planned, information in the inventory of asbestos in place must be adequately detailed with respect to the work carried out. So it must state clearly what kind of work will take place. Clients must ensure that a copy of the inventory of asbestos in place or the relevant part thereof is given to the mandatory or contractor before any asbestos removal or repair work takes place. So if a plumber comes on site and he is expected to work in the vicinity where there is asbestos in place, he should be given this information. Given to the registered asbestos contractor or approved inspection authority, readily accessible to the employees and the health and safety committee. In the case of transfer of ownership of the premises or the property, this inventory must also be provided to the new owner of the premises. And here's a secondary safeguard is for the improved inspection authority to obtain the inventory of asbestos in place. The mandatory who carries out asbestos removal work or repair work must obtain a copy of the inventory of asbestos in place from the employer or the self-employed person. If suspected asbestos containing materials are located in the structure, plant, or machinery, inform the employer or the asbestos client, who must ensure that the competent person determines whether or not substance is in question is indeed asbestos containing material. In the event of work carried out in the workplace and potential exposure to airborne asbestos, the employer, self-employed person or client must ensure that the person authorized to do such work is given a copy of the asbestos in place. The authorized person, the person authorizing the work as contemplated from the inventory of asbestos in place must determine the future task and incident related to potential exposure. Employer, self-employed person, as the case may be, must ensure that the recommended controls are implemented with regards to the work. All asbestos containing materials listed in the inventory of asbestos in place must be clearly labeled and provided with signage in accordance to Regulation 20. Now, maybe just on this point, this is also new, but this is also no reason to start panicking or to be worried about. The intent is not for these labels now to change the color scheme in every room to black and yellow. That is not the intent. The intent is for anybody who enters a building or a room and there is asbestos in place, for them to be able to identify it. but not to the extent where, you know, we have posters the size of A3s indicating this is now an asbestos sheet. Where it will become important is where we have access to areas like roofs, which contains asbestos. So at those access points where you get onto the roof, you would expect to see some signage there that will indicate to you whether or not this material is asbestos. Then moving on to the asbestos risk assessment. If asbestos is identified in terms of the Regulation 3, then the employer or self-employed person must ensure that the asbestos risk assessment is carried out at intervals not exceeding 24 months. You will see that risk assessment is expected at different stages in the life cycle of the asbestos material. So this risk assessment referred to here is where we are dealing with asbestos in place. There might not be any intention or any need at this point to remove that asbestos, but we need to have a risk assessment. Other risk assessments will follow and will have other details when we decide that removal is actually needed. So an employer, before causing a risk assessment to be made, consult with the relevant health and safety committee and inform them in writing of the arrangements made for the risk assessment to be carried out. The asbestos risk assessment must, as an outcome, have the risk categorization. So what we need here is to categorize the asbestos materials in accordance of importance, or which ones needs attention more urgently. And this categorization will be derived from the following: the health impacts of asbestos, the number of persons potentially exposed at the workplace, the potential for damage or disturbance of the asbestos materials. So if this asbestos material is in a panel that are prone to being struck by a forklift, then obviously the potential for damage will escalate the importance or the risk relating to that piece of asbestos containing material. The condition of the asbestos containing material, including the state of deterioration. The risk categorization must be used to determine the need for keeping in place, repair, or removal of the asbestos containing material. So from that risk assessment, the employer must decide now, am I going to keep it? Am I going to maintain it in place? And how am I going to keep it in a good state of repair that fibers are not released? Or am I going to be removing it? And when will I be removing it? How will I be removing it? So all of this will emanate from the risk assessment. The asbestos risk assessment for repair work must include the risk of any asbestos exposure relating to each job step, the controls that are necessary, indication whether environmental air monitoring is required to determine the exposure of adjacent communities. If exposure risks indicate that the OEL may be exceeded, and indication that the employer must obtain the services of occupational medical practitioner. The asbestos risk assessment for asbestos removal work. So this removal work now refers to type 2 and type 3 work, must consider the risk assessment carried out in accordance to Regulation 12, which is the duties of a registered asbestos contractor, the potential exposure of persons other than employees, the potential contamination of air, ground, and water, throughout the decontamination of the thorough decontamination of employees in the workplace, transportation of asbestos-containing materials and asbestos waste, and then possible emergency scenarios. An employee must obtain the services of an approved inspection authority that must review and endorse the following at intervals not exceeding 6 years: the inventory of asbestos in place and the asbestos risk assessment, provided that the review and endorsement is not required if the initial risk assessment and inventory was developed by an approved inspection authority. Then asbestos management plans, and this is now also new. This is now something that needs to be developed going forward. If asbestos containing materials are identified, the employer must ensure that a written asbestos management plan for the workplace is prepared by a competent person. Now, once again, the competent person comes up here, and you will see the reason for the definition being so general. Competency for drawing up a management plan might be different from the competency required to do an inventory and different from a person competent to do the training. The asbestos management plan must include at least the following: the procedure relating to the implementation of those regulations dealing with inventory, risk assessment, and labeling, the repair and removal and management of asbestos-containing materials, and the implementation of the regulations for the prohibition of the use, manufacture, import, and export of asbestos. Where asbestos-containing materials have been identified in the inventory of asbestos in place, a specific procedure which will, as far as reasonably practical, reduce the risk of exposure, as well as incidental exposure for the following scenarios: an incident, an emergency, removal work, as well as repair work. So all these scenarios must be considered and included in the management place. A policy, procedure, and implementation phase plan for the phasing out of existing asbestos-containing materials. So there was a question already this morning, when is South Africa expected to have removed all asbestos in place? So no, there isn't a national policy currently with a cutoff date when all buildings must be asbestos-free. But this requirement of the asbestos management plan, C there, requires each employer to themselves develop a policy and procedure as how they're going to be phasing out asbestos in their buildings. So, and this is where we get to the term asbestos abatement. We are moving away from the asbestos risk. So each company can then come up with their own time frames as to when they will then start phasing out and removing asbestos. And if for the next 10 years they feel comfortable that the state of repair is such that they can keep it in place, that's fine. But we want to see an indication as to moving away and phasing out. The employer or self-employed person must review and, if necessary, revise the asbestos management plan as new technology obviously becomes available and new decisions are made, or even if there is damage to buildings. This might change the management plan. These intervals may not exceed 8 years. Okay, now we're moving on to another important regulation. And this is not a new regulation, but what you will note is new or different from the old regulation is that we have divided employees that might be at risk of asbestos exposure into 3 categories. So basically ranging from the ones that are very unlikely to be exposed to asbestos to the ones that we actually employ to be working with asbestos. So the requirements for training for these different categories of employees are obviously important. So employer must provide to a person who may be incidentally exposed to asbestos with information, instruction, and training. So these employees that may be incidentally exposed are the ones that are working in a building that are containing asbestos materials, but there is no expectation for them to be working with the asbestos or even to be exposed to it. But they need to know that there is asbestos in that building. So they need to be provided training through the induction training upon employment and where the inventory of asbestos in place is reviewed. Excuse me. Ensuring the information, instruction, and training contemplated at least consider the sources of potential exposure the potential health risk associated to exposure, the procedures including exposure control and personal decontamination to be followed, the safe disposal of asbestos waste, procedures for record keeping, and the inventory of asbestos in place. Where an employee undertakes non-asbestos related work where there is a potential for exposure to asbestos dust, the employer must ensure that the employee is adequately and comprehensively informed, instructed, and trained in both practical and non-practical knowledge. So these workers would be the ones that, once again, is not employed to actually be working with the asbestos, but in their task, they are likely to come across the asbestos-containing materials, and there is a risk of them actually disturbing these materials. So here we are thinking of maybe plumbers and electricians that are moving in these spaces where we can find asbestos-containing materials. So they need information with regards to the source of potential exposure, the potential health risks associated with exposure, the tasks and incidents relating to exposure scenarios, procedures to be followed in the event of accidental disturbance. Yeah. And then moving on to, I think, the final category, in the case of actual asbestos removal, this is where we actually employ somebody to be working with asbestos. So obviously they need much more comprehensive information, instruction and training in both practical and theoretical knowledge with regards to the OEL and its meaning, the importance of good housekeeping at the workplace, fall protection, the correct use of personal protective equipment and personal hygiene, the contents of the plan of work, the correct use of control measures to limit the spread of asbestos dust, the control measures to limit the exposure of employees inside the regulated asbestos area, and there's a definition for regulated asbestos area, procedures to follow in the event of accidental spills or disturbances, procedures for reporting the occurrence of failance of control measures, and the safe disposal of asbestos waste. The training contemplated in the previous sub-regulation must be provided by a person deemed competent by the Chief Inspector. Have a minimum contact duration of 8 hours and have as an outcome provide the employee with a training certificate. So there is a requirement for the duration of the training to ensure that just because the employer is now in a rush to get a job started, that they don't neglect the information, instruction, and training of these employees. This is of vital importance for them to understand what the risks are and what is expected of them. You will also note that the regulation very specifically deals with information as well as instruction, as well as training, and in some cases even supervision. So all 4 of these areas needs to be paid attention to. Just to say that employees have been trained is not adequate. Refresher training with a minimum contact duration of 2 hours must be provided at least annually. And more frequently if the work methods have changed, the type of work to be carried out have changed. So if the contractor has, for instance, moved from doing type 2 asbestos work to doing type 3 asbestos work, the training needs to be repeated. The type of equipment used have changed, and if it is deemed a requirement by the Occupational Health and Safety Committee, the refresher training must be repeated more often than annually. An employer must ensure that an up-to-date record is kept of the employee's training, must be made available at the place of work. So if off-site work is taking place at a client site, those records must be available. An employer must ensure that current employee training certificates are provided to the employee on termination of employment. This is also a new requirement, and the idea behind this is, so if a specific employee is moving on to another employer or to another contractor, they don't need to be retrained. So they can then obtain their training certificate, and that will make them more employable at the next level because they have already been trained. Obviously, within the validity period of that certificate, they can then use this to obtain employment again. Now, duties of persons who may be exposed. This is quite a long regulation. And that just illustrates that all the responsibilities and duties does not fall on the employer. Employees who may be exposed to asbestos definitely have responsibilities as well. And once again, this regulation is divided into those three categories of employees that we dealt with under information, instruction, and training. So employees who may be exposed to asbestos in the workplace must obey any lawful instruction, attend asbestos awareness training on the inventory of asbestos in place, and report any asbestos contaminating material that has been damaged. Then the next level is persons involved in non-asbestos related maintenance. So once again, we are talking about our electricians, maintenance staff. They must obtain a copy of the relevant part of the inventory of asbestos in place, prevent damage or disturbance of the asbestos in place, and if damage or disturbance occurs, stop work immediately and report such damage to the employer or the Health and Safety Committee. Then a person who is involved in type 1 asbestos work must obey any lawful instructions pertaining to occupational health and safety given by or on behalf of the employer regarding the acquisition and copy of the relevant part of the inventory of asbestos in place, decontamination of the regulated asbestos area. And we'll deal with that area in Regulation 18. As far as reasonably practical, ensure that non-destructive wet methods are used during the removal procedure. The use of appropriate tools and equipment to limit the release of dust, appropriate type and use of personal protective equipment, a thorough decontamination of equipment, the containment and labeling in terms of Regulation 20, and the disposal of asbestos waste, the disposal and use of disposal overalls and respiratory protective equipment where applicable as asbestos waste. And then the last category is our asbestos contractors doing type 2 and type 3 work. So they must also obey any lawful instruction pertaining to occupational health and safety, and also compliance with the requirements of the asbestos plan of work that was submitted. As far as reasonably practical, use and non-destructive wet methods must be employed. The prevention of asbestos dust becoming airborne, appropriate type and use of personal protective equipment and clothing, wearing of monitoring equipment. So this is now a duty of the employee. They should be aware of before employment. And if reporting for medical surveillance as required by the regulation, the cleaning up and disposal of asbestos waste, decontamination of structures of the workplace and building, housekeeping at the workplace, personal hygiene, good environmental and health practices, information and training received as contemplated in the previous regulation, and then correct decontamination procedure that must be followed. An employer must ensure that the exposure of a person to asbestos is either prevented or, when not reasonably practical, adequately controlled, provided that the control of exposure is regarded as adequate if the measured airborne concentrations of regulated fibers are below the OEL. Now the OEL has also changed. Now it's 0.1 regulated fibers per milliliter of air. And where the regulated fibers measured are above the OEL for asbestos, but the reasons have been identified and action has been taken. So control of asbestos exposure where practicable, the employer must control exposure to asbestos by limiting the number of persons who will be exposed, limiting the duration of exposure, and limiting the amount of asbestos dust that is generated. By introducing engineering control measures, control the asbestos exposure, which may include the following: process separation or enclosure, bonding of asbestos fibers with other materials using wet methods, and the provision of negative pressure and filtration systems. With regard to the contamination of water with asbestos, an employer or self-employed person must ensure that any water that is contaminated with asbestos as a result of asbestos work being performed is passed through a filtration system. So this is very much similar to what we've been doing in the past. Control will also be, exposure will also be controlled by introducing appropriate written work procedure that an employer must follow, and must ensure that asbestos contaminated materials are safely handled and disposed of in an appropriate manner. Installation equipment and tools are safely used, decontaminated, and maintained. And where there is an incident or a spill, it must be reported to the Provincial Department of Labour and Employment offices. Now, notification of asbestos work, there is also a few changes with regards to that in the regulation. So no person or asbestos client may carry out any type 1 asbestos work unless the Chief Director, Provincial Operations of the relevant provincial office has been notified in writing at least 7 days prior to the work commencing. So please note here, although there's a lot of allowances under the type 1 asbestos work, notification still needs to be provided to the Department of Labour and Employment. No employer or client may carry out type 2 or type 3 asbestos work unless the Chief Director, Provincial Operations of the relevant provincial office have been notified in writing, once again, at least 7 days prior to the commencement of such work. This is important to note. A shorter time period for notification may be allowed by the Chief Director. So this is not a given. This is something that needs to be negotiated or, with the provincial office of the department in the case of emergency work. So this is not a question of a contractor deciding themselves, oh, this is an emergency, and continuing with the work. The department must be acknowledged and known in this process, and it's still up to the Chief Director of that office to decide whether or not they agree that it is emergency work and that the notification period can be waived. We find that a lot of times emergency work is considered as I forgot to give notice, so now it's an emergency. And that is actually not the intention here. So written notification must be provided in the format indicated in Annexure 2. You will see this annexure is very similar to the notification document provided in the construction regulation. It was done in that way on purpose. But please note that if the asbestos work is just a part of the construction work, both notification for construction work as well as notification for asbestos work needs to be provided. And then the provincial office of the department will then acknowledge receipt of this notification, this written notification receipt. Duties of the asbestos client for asbestos work. An asbestos client carrying out type 1 asbestos work must provide an up-to-date inventory of asbestos in place, ensure that an asbestos risk assessment is carried out prior to asbestos work, ensure that a written safe work procedure is developed and followed, and as far as reasonably practical, will provide adequate information, instruction, and training to any person who may be exposed to asbestos. So without this SOP, the safe operating procedure, and the other limitations put on type 1 asbestos work, as I said before, this work can then not be done safely enough. So it's very important that the limitations and the safeguards put in place with regards to the type of material, the time, the size of the material that can be removed is strictly adhered to. Otherwise, it cannot be done safely. And asbestos client planning type 2 or type 3 asbestos work, excuse me, must provide an up-to-date inventory of asbestos in place to the registered asbestos contractor and the approved inspection authority. If the asbestos containing materials intended for removal or repair is not identified in the inventory of asbestos in place, then the inventory must first be reviewed and updated before the work may start. Ensure that the asbestos risk assessment is carried out prior to the asbestos work. Appoint in writing approved inspection authority. Ensure that the appropriate registered asbestos contractor performs type 2 or type 3 asbestos work as per the plan of work, and ensure notification is given, and ensure that they have co-signed the asbestos plan and the asbestos repair or removal to be carried out. Just to go back to then the point E there with regards to the contractor working according to the appropriate registered level. So currently we have a group of contractors registered as asbestos contractors. There is no referral to the type of work, type 2 or type 3 work that they are allowed. So what is going to happen? We're going to have a period where all the contractors on the current list are allowed to do type 2 work. No questions asked. They will be allowed to operate under their current valid certificates, and some of them only expire in 2022 and 2023. So they will be allowed with that certificate to perform type 2 asbestos work. Any company who's wanting to move on and do type 3 asbestos work can reapply to the department and get recertification, and they will then be issued with a certificate indicating that they are then allowed to do both type 2 and type 3 work. So I hope that clarifies the question with regards to currently registered contractors. You are not expected to now immediately apply for registration again. If you're intending to do type 2 asbestos work, you can continue with your current certificate until it expires. But for those of you wanting to perform type 3 asbestos work, please contact the department again for registration on that level. Asbestos client must also stop any registered asbestos contractor form exceeding any asbestos work if it poses a high risk to health or safety. Before any asbestos work commences on site, ensure that the registered asbestos contractor is in good standing with the compensation fund. Where fatality or permanent disability injury occurred, then report this to the Chief Director of Provincial Operations of the relevant provincial office. After completion of type 2 or type 3 asbestos work, the asbestos client must obtain asbestos clearance certificate from the approved inspection authority. So this is now a duty on the client as well, to make sure that before he reoccupies a space that it was properly cleared and certified cleared by approved inspection authority. So duties of a registered asbestos contractor for asbestos work. So as only type 2 and type 3 asbestos work is requiring registration, this duty now only falls to those contractors. And the asbestos contractor must undertake only the type of asbestos work for which they are registered with the Chief Inspector. So as I said before, this new certificates that we will issue for type 3 asbestos work, that certificate will state that this contractor can do both type 2 and type 3 work. But companies only registering to do type 2 work, they will receive a certificate only mentioning type 2 asbestos work. And then a contractor will then be limited to the scope of those specific types of work. The contractor is also expected to appoint an occupational health and safety representative. This is now irrespective of the number of employees in their employment, and obtain a copy of the up-to-date inventory of asbestos in place prior to the asbestos work starting. Before commencement of any asbestos work and during such work, the contractor must ensure that the risk assessment is performed and includes the identification of the risks, assessment of the risk related to the hazard based on a documented method, and the documented control measures to mitigate this risk. The risk assessment contemplated is reviewed at regular documented intervals. So this document must state how often it will be reviewed, when an incident has occurred and when the scope of work has changed. An up-to-date copy of the risk assessment must be made available on the relevant site. The registered asbestos contractor must ensure that the approved plan of work is submitted to the Chief Director of the relevant provincial office. Appoint in writing asbestos removal supervisor. This is now also a new written appointment for each asbestos work site, who must ensure that occupational health and safety compliance on the site, compliance with safe asbestos removal and repair procedure, the correct use of PPE, and proper decontamination of waste. The contractor must also adhere to the repair and removal methodology, associated control measures provided in the plan of work. So the contractor must just follow the plan of work and ensure that the employee medical and training records are available on site for inspection and validation. The registered contractor must also ensure that at least the following information of every employee is recorded and kept for a minimum period of 50 years. You will see that there's an increase in the time period. The physical address of every asbestos work project, the person was, and then the name and identification number of the employee. This is in order for the person's occupational exposure to asbestos to be verified and traced back. Excuse me. Before commencement of asbestos work, ensure that an approved inspection authority has been appointed in writing by the asbestos client. The registered asbestos contractor is registered and in good standing with the compensation fund, and where a fatality occurs, it must be reported. Excuse me. Okay. Then duties of the approved inspection authority for asbestos work. An AIA involved in type 2 or type 3 asbestos work must ensure that the appropriately registered asbestos contractor performs only type 2 or type 3 asbestos work. So once again, as I said, whatever is indicated on the certificate, that is the limitations of the kind of work that is allowed to be performed by that contractor. Obtain a copy of the up-to-date inventory of asbestos and in place, and in consultation with the registered asbestos contractor, compile a plan of work. So why we made this a dual responsibility is we're trying to prevent the scenarios where an AIA in sort of isolation then draws up a plan of work and submits it to the department. And then once everybody gets to site, then the contractor who's actually supposed to follow that plan of work has got no idea of what is in that plan of work. So it's now a dual responsibility for both of these parties to draw up this plan of work and make sure that they know what is the contents and that they are comfortable in following it. The AIA must also approve and submit the plan of work at least 7 days prior to commencement to the provincial office, receive acknowledgement from the provincial office, confirm the employees' medical and training records, provide guidance and step-by-step instructions on the instruction to the contractor on the approved plan. So this plan must be discussed and they must know the contents and inspect adherence to the approved plan as well. The AIA must also stop any registered asbestos contractor from executing any asbestos work which poses a health or safety risk, perform planned asbestos air monitoring, and issue a written report which indicates findings and, where necessary, recommendations to the client and the contractor. Ensure that upon completion of type 2 and type 3 asbestos work, clearance is provided to the client. So this is probably the second shortest regulation that we need to deal with today, and it's regarding disputes. So in short, what it says is that if there is uncertainty whether or not a certain type of work that needs to be performed falls under type 2, type 1, type 2, or type 3 work, then the employee responsible for the work area is to be carried out must obtain the services of an approved inspection authority that can make the determination whether or not this work that is required is either type 1, type 2, or type 3 work. The employer self-employed person responsible for the work area where the asbestos is carried out must refer the dispute to the chief inspector, who must then make a decision on the type of work that needs to be performed. So this is just to make sure that we all get comfortable with the different types of asbestos work that is allowed, and that, as I said, especially when it comes to type 1 work, if we don't stick to those limitations, the risk just exceeds the benefits, and it's not appropriate to then do it under type 1 work. So, and then should a dispute arise over the implementation of the regulation above, the affected person may appeal against the interpretation of the chief inspector. Then moving on to the plan of work, a written approved plan of work must include at least the following: the name and contact details of the contractor, the AIA, the waste transporter, as well as the asbestos client. The name and contact details of the asbestos removal supervisor, who needs to be appointed in writing by the contractor for that specific site, the details of the asbestos to be removed, the list of the employees, name and identification with validation of training and medical certificates, expected commencement and completion dates, air monitoring method and frequency, detail of how the asbestos removal work will take place, including the method of removal tools and equipment, details relating to the requirements of decontamination facilities and decontamination procedures, details of demarcation, labeling and signage requirements for asbestos area, and procedures for decontamination of work area, tools and equipment, emergency procedures in the event of uncontrolled asbestos release. Methods for disposal, details of the asbestos clearance certification. So what will be considered the specifications that needs to be addressed for the clearance certification, and then any specific relevant prohibitions. So if there is anything on site that requires an additional prohibition, it must be included in the plan of work. An approved plan of work must contain the signatures of the asbestos client, the registered asbestos contractor, and the approved inspection authority. So the hope is here that this requirements will then ensure buy-in from all of three of these parties, and that we don't pass the buck in saying working with asbestos safely is the responsibility of another party. All three of these parties involved needs to take responsibility, and by signing the approved plan of work, they then commit to that. And air monitoring in the case of type 2 and type 3 asbestos work, an asbestos client must ensure that air monitoring of the concentrations of airborne regulated fibers are performed. And it's performed by an approved inspection authority, carried out in terms of the HSG 248, and there is a definition for that in the regulation, representative of employees' exposure, and carried out at a frequency determined by the approved inspection authority based on a site-specific asbestos risk assessment. So if the material that we are dealing with is especially in a poor state, then we would expect for maybe sampling to be done more frequently or more samples to be taken to ensure that we keep everybody safe. The results of the air monitoring obtained must be compared to the OEL or the OEL STEL, the short term. Environmental air monitoring must be performed by approved inspection authority during type 2 and type 3 asbestos work. Air monitoring referred to must be carried out only after the relevant Health and Safety Committee has been consulted and given opportunity. Then moving on to medical surveillance, you would have also noticed that there is some significant changes to the approach to the medical surveillance, but I think it's a very nice workable system that is required now. An employer must establish and maintain a system of medical surveillance of employees if an employer is registered as a contractor. In the opinion of occupational medical practitioner, it is needed, and the occupational medical practitioner recommends that the relevant employee should be under medical surveillance. So in those cases, then a system of medical surveillance must be maintained. An employer must appoint an occupational medical practitioner to document the system. So two documents here, the written appointment of the medical practitioner, as well as a documented system of medical surveillance that includes the consideration of the risk of developing an occupational asbestos-related disease, medical fitness to work requirements, and initial health evaluation before commencement of asbestos work, which will comprise employees' medical, occupational exposure, and social history, appropriate physical examination, test, radiography, and any other medical examinations deemed necessary. Periodical health evaluations conducted at the intervals mentioned. The duty of the occupational health practitioner will also be stipulated in this written system, and making the document system for medical surveillance available to the Health and Safety Committee. The appointed occupational medical practitioner must notify the employee in writing of the outcome of the health evaluation by issuing a certificate of medical surveillance subject to the following. The information provided to the employer is limited to the presence of an occupational disease and the fitness of that employee. So no confidential personal information may be shared by the practitioner with the employer. The employee is informed of the outcome of his medical evaluation, and the employee is assessed to be temporarily medically unfit to perform work if there is a reasonable expectation that the employee's health will improve and that such employee will be able to return to work. An employer may not permit an employee who was certified by the occupational medical practitioner as medically unfit to work in a regulated asbestos fiber, and after being informed of the result of exposure of assessment and being prescribed medical tests in a frequency that should be repeated based on the risk. Certificate of medical surveillance must be provided to the employer, by the employer to the employee upon determination of employment. This is similar to what we envision for the training certificates. So if this employee has still got a valid medical certification and are leaving employment for another employer, they must be provided with this document, once again, to make them more employable at the next place they may be applying to. May be used for subsequent asbestos work. So the idea is also not to overexpose any one employee moving maybe from one employer to another to all these medical tests. If they still have a valid certificate in hand, that must be recognized by the next employer and they can continue working under that certification. An employer must record, investigate, and report the occupational diseases contemplated in other regulations, and employer must ensure that the employee provides written information, informed consent on the inclusion into a medical surveillance program. So this is also something that needs to take place before or at employment. That consent needs to be provided. We can't have persons working with asbestos and not making themselves available for medical surveillance programs. Then regulated asbestos area. So this is the area we envision where asbestos removal will take place, and there are certain requirements with regards to keeping everybody in the vicinity and everybody in that work environment safe. So these areas needs to be demarcated. So where type 1, type 2 or type 3 work is undertaken, this area must be clearly demarcated and identified with the markings in Regulation 20. Ensure that no person enters or remains in a regulated asbestos area unless he or she wears the appropriate type and correctly fitting as respirator protection and protective clothing. So just providing a worker with respiratory protective equipment is not adequate. It is the responsibility of the employer to ensure that that respirator is correctly fitting. The employer must provide respiratory protective equipment and protective clothing suitable to protect against the regulated asbestos fiber to all persons who may be exposed to asbestos. Ensure that the protective equipment provides appropriate level of protection and ensure that the person's exposure is adequately controlled. Then personal protective equipment is provided. The employer must ensure that the relevant equipment is capable of keeping the exposure level to below the OEL. So it's important to make sure that the correct masks are provided. For instance, we can't provide a cloth mask to somebody doing asbestos work and say they have been provided. It needs to be capable of keeping the exposure level to below the OEL. The relevant equipment is correctly and properly used. Information, instruction, training, and supervision that are necessary with regards to the use of the equipment are provided. So once again, it's not adequate to just provide a mask to an employee. They need to be trained, they need to be instructed, and they need to be supervised on the correct use. Keep the equipment in a good condition and effective working order. An employer must ensure that all personal protective equipment contaminated with asbestos dust are thoroughly cleaned and handled in accordance with the following procedures. Where personal protective equipment is cleaned on the premises of the asbestos client, care must be taken to prevent the contamination during handling, transport, and cleaning. Water that is used for decontamination or cleaning must be filtered in accordance to the requirements in Regulation 9. And employer must ensure that no person removes dirty or contaminated personal protective equipment from the workplace. Subject to the facility regulations, provide employees involved in type 1 and type 2 asbestos work with adequate washing facilities, and provide employees involved in type 3 asbestos work with decontamination facilities to enable the employee to meet the standards of personal hygiene. Then the regulation dealing with the labeling and signage. And as I said, this is now new as there is an expectation to label asbestos materials in place. So all asbestos in place must be clearly and legibly identified using the pictograms specified in Annexure 1. So once again, as I said, the idea is not to have these labels and stickers all over the place, but at places where it makes sense, where people might need the information to know whether or not asbestos is contained in this material. for instance, where you have an access point to avoid in the ceiling, that will be a good place to put the labeling of the asbestos material that is contained in that void. All asbestos waste must be clearly labelled using the labels specified, and as far as reasonably practical, use clearly visible and significant number of labels to ensure that everybody can see that it is asbestos waste. Any asbestos contaminated soil or land contaminated with asbestos waste must be clearly demarcated and signposted using the specified signatures. So this is also intended where we have maybe a big premises and somewhere in the corner of the premises there is some raw asbestos or asbestos waste. These areas must then be clearly demarcated and indicated that the soil is then contaminated with naturally occurring asbestos. Any regulated asbestos area must be clearly demarcated using the pictograms. So the regulated asbestos area is identified and there is a regulation dealing with that. So what is expected if asbestos work, type 1, 2 or 3 work is taking place, that these areas must be demarcated using the signage and pictograms so as to control access to those areas. Then disposal of asbestos, an employer must ensure that all asbestos waste is placed in containers that will prevent exposure during handling. Maybe before I go on with this part, just to illustrate here, we keep on referring to employer here, but in this relationship between a client and a contractor, both of those are considered employers. So in this case specifically, the responsibility will most likely fall more on the contractor themselves, but they are an employer in their own right that needs to adhere to these specifications. So the waste must then, the employer must then ensure that all asbestos waste is placed in containers that will prevent exposure during handling. The premises, structural or area are thoroughly checked to ensure that all the asbestos waste intended for disposal has been removed. All vehicles and reusable containers or any other articles are cleaned and decontaminated, and document is obtained from the asbestos disposal site to just confirm final destruction of the asbestos waste. All persons involved in the collection, transport and disposal of asbestos waste are provided with suitable personal protective equipment. This is an area that is often neglected. The person transporting the waste are forgotten when we are providing personal protective equipment. The drivers of the vehicles are also provided with written instructions on the material that they are transporting and what are the safety precautions that they are responsible for. Then asbestos clearance certificate. Following the completion of type 2 or type 3 asbestos work, the approved inspection authority must conduct a thorough visual inspection. So it's not just a matter of setting up area samples and pumps to take some samples. There needs to be a visual walkthrough to see if actually all asbestos waste has been collected and disposed of. Conduct air sampling to ensure compliance with the clearance indicator. Ensure that all asbestos waste has been removed and issue a written declaration for the purpose of clearance certification. So we are expecting a written document to be handed over to both the contractor and the client saying the AIA has checked and double checked and make sure that the levels are now safe and no visible asbestos is left behind. So reoccupation may take place. Then moving on to records, the employer must keep records of all inventories of asbestos in place, asbestos risk assessment, air monitoring result, medical surveillance reports, disposal certificates and clearance certificates. Make the records contemplated available to the inspector, and make records of all assessment surveys, air monitoring results and asbestos inventory available for perusal by the relevant Health and Safety Committee. Keep all records for a minimum period of 50 years. This change has come about because of some literature that indicate that the latency period of asbestos-related diseases can be extended to as much as 50 years. So this has then changed from the previous 40 years. Keep records of training given to the employee as long as the employee remains employed. Then the prohibitions, and I would endeavor to say that this is probably, besides all the new definitions, probably the most important regulation that we need to take cognizance of, especially now in these first couple of months where we are all trying to find our way around this, the implementation of this new regulation. The prohibitions are extremely important. So moving on with that, then no person may sell, donate, reuse, reinstall, or recycle any asbestos or asbestos-containing material. So the intention of having this long list of things that we cannot do is to ensure that we don't just transfer the risk of asbestos to another time or another person or another place. And the Director General also said it in his address this morning, that this is not the intention of this regulation to move the risk of us that we know asbestos or just to another place or another time. We are trying to eliminate that risk. We are trying to abate that risk of asbestos. So no asbestos material may be sold, donated, reused, or reinstalled or recycled. So if an asbestos sheet is removed from your roof, it needs to be disposed of. You can't reinstall it just on another building or another place. It cannot be reused. Clean, no person may clean or prepare the surfaces of asbestos cement materials. So this is now with regards to the preparation of, before we actually do any work on these products. The surface preparation, as I said earlier, is where the fibers actually gets the release, and that is where we are facing problems. So no person may store any asbestos or asbestos-containing materials for longer than 3 months after completion of asbestos removal work before final disposal. So the reason for us providing this temporary storage is because we do realize the expenses when it comes to final disposal. It is not a cheap thing to do. And as it is the only option currently, we wanted to make accommodation for contractors to be allowed to make it sort of worth their while, or worth the trip down to the disposal site. So if they have several small jobs, they are allowed to store the waste for a limited time period of 3 months to accumulate some more waste to make the trip more worth spending that money. So that's the only idea behind this allowance. But this storing of the asbestos contaminated materials may not be done if it is uncovered or unprotected or stored in a manner that may contaminate the ground or water systems. So this waste that are being stored for this short period of 3 months must be protected from the elements so that fiber release are prevented. No person may use compressed air or permit the use of compressed air to clean off any person or any surface. And no person may use electrical power tools such as angle grinders or any other fast-moving equipment to cut or grind or drill into asbestos-containing materials. No person may smoke, eat, or drink or key beverages, and no person may use a vacuum cleaner other than a vacuum cleaner with a HEPA filter. Carry out any demolition work. This is an important one. No person may carry out any demolition work before all asbestos and asbestos-containing materials has been identified in the inventory of asbestos in place, safely removed or otherwise controlled, as far as being practicable or so far as to eliminate the uncontrolled release of asbestos fiber. So as I said initially, where we refer to demolition work in the past now, demolition work as defined in the construction regulation is not allowed for asbestos. So asbestos materials needs to be removed before any demolition work may start. Then offences and penalties, it's just straightforward. It's similar to what we had with a little bit of an increase there. And then the regulations these asbestos abatement regulations are repealing the old asbestos regulations of 2001. And the regulations will be known as the Asbestos Abatement Regulations and will come into effect on publication of the regulations in the Government Gazette, and that happened on the 10th of November already. But Regulation 3 and Regulation 20 will have an implementation time period of 18 months. So we expect to compliance with those regulations only in 18 months, or at this stage it's about 17 months left to do that. So the implication there is that the Regulation 3 dealing with the identification of asbestos in place, and then following on the inventory of asbestos in place and the management plan of asbestos in place, all those, everybody's got 18 months to develop those plans and put them in place, as well as the labeling of asbestos in place. So we would expect in 17 months to see labels on asbestos in place, roof sheets marked to indicate that these are actually materials containing asbestos. Then Annexure 1 deals with the two different types of signage that can be used to identify asbestos. So we would expect to see this asbestos warning sign on asbestos containing materials in our current buildings. In about 18 months, we should start seeing this black and yellow labeling there. And as I said, once again, the idea is not for this to be overwhelming and or the purpose to scare anybody, but for people to be informed, to have this signage posted where the information is needed. And then just the warning labels that can be used, especially on asbestos waste. Then unfortunately, the print here is very small, but this is an Annexure 2. It's a copy of the notification of asbestos work, and this can be used or must be used then for notification to the Department of Employment and Labour with regards to type 1, type 2, and type 3 work. And you'll see there's just a little note there at the bottom. There's one or two of the areas that are not applicable for type 1 work, but the rest of the document should then be completed to notify the department of the work. And yeah, then the department will also acknowledge receipt of this document. So, ladies and gentlemen, that brings me to the end of my presentation. And in closing, I would just like to point out a link there at the bottom of the slide. And it was also circulated through the slides that Ashraf showed this morning before we started. It's a YouTube video that the department has developed with regards to the Asbestos Abatement Regulations. And you are welcome to go have a look at that YouTube video. I'm sure that you will find it very informative. So with that, I'd like to thank you and then hand back over to Ashraf. Thank you, Ashraf.
Well, thank you very much for that, Elise, and congratulations. That was particularly a marathon session from your side, but I'm sure all of the attendees of the launch of the Department of Employment and Labour's Asbestos Abatement Regulations 2020 would appreciate the thorough look at what you've shared with them. Some of those comments have been made on the chat box as well. One particular comment also just there to bring to the attention of the Director General. There was some comment by Dr. Jim Tavatanodea saying that the historic background that he presented was, I think, useful and important, and asked if that could be shared, Elise. So thank you very much. That was Elise Lawrence dealing with the Asbestos Abatement Regulations 2020 in much detail. I'm now going to hand over immediately to my colleague, Mr. Gabriel Mizan from the NIOH's Occupational Hygiene section, and he's going to be dealing with asbestos sampling. Are you sharing your audio, Gabby?
Yes, I am.
And while Gabby is just preparing his slides, a reminder that I have posted that particular YouTube link that was just mentioned by Elise on the chat box as well, including the link to the actual regulations and contact details of two colleagues, Mr. Kumalo and Ms. Gubeni, who will be dealing with post-webinar any details you require regarding the asbestos abatement regulations. So please contact them. The email addresses and contact numbers are also there in the chat box. I now, Gabby, thank you very much. I can see your full screen slide and I can hear your audio while I'm handing over to you. Thank you for sharing your presentation with us today.
Thank you, Ashraf. Good morning, everyone. It's still morning. And thank you, Elise. That was a very comprehensive presentation on the regulations. Luckily, my presentation won't be that long. And I'm going to be covering asbestos sampling. Ashraf, can you hear me okay?
Yes, we can. Please proceed. Thank you.
Okay, great. So I'm going to be talking about asbestos sampling. This is really not, the aim is not really to make us experts on asbestos sampling, but just really give us an idea what asbestos sampling actually entails. And also the legal requirements related to sampling. So let's start with the legal requirements. Elise covered this already, but maybe just to summarize what was said and remind us that we need to do air monitoring for asbestos. As hygienists, we like to call it sampling, personal and environmental sampling in case of type 2 and 3 asbestos work. The sampling must be done by an approved inspection authority. It must be carried out following the SAG 248, and this is new in the abatement regulations, the mentioning of the HSG 248. This is actually already like a 15-year-old document that was published in the UK by the Health and Safety Executive. And it's really like the Bible for asbestos sampling, analysis, supervision, and all that. So I'm quite happy that we have actually adopted this important document. The sampling must be representative of the worker's exposure, and it must be carried out at a frequency determined by the AIA and based on the risk assessment, and Elise covered this. The results need to be compared to the occupational exposure limit or the short-term exposure limit. And what the regulations also tell us that whenever we're doing asbestos monitoring or sampling, it must be done in consultation with the health and safety representatives and committee. So why do we sample for asbestos? First of all, and the most important reason, of course, is to determine compliance with our occupational exposure limit. But there are some other important reasons. For example, we want to verify the effectiveness of our control measures. So if we are applying, for example, wet methods, we want to know how effective our controls are. Assess the suitability of respiratory protective equipment. So we want to know what type of respirator we need, and that would be based on the concentrations of the asbestos in the air. Leakage testing. So this is testing that is done often outside an asbestos enclosure to see that it's really effective in containing the fibers. Background sampling, this is typically done before we start an asbestos work, asbestos removal or demolition, whatever it is. We want to know what the background levels of asbestos are. The HSG 248 also mentioned something called reassurance sampling. which is basically also related to after we've dismantled an asbestos enclosure to make sure that the area is clean. And I've highlighted clearance sampling, which is mentioned in our regulations specifically. And this is again after we've completed asbestos removal, asbestos work, and cleanup. We want to make sure that asbestos levels in the air are acceptable. So the types of sampling and the applicable regulated limits. So for personal sampling, which is exposure sampling, the purpose is to determine compliance, and we have two regulated limits, the 0.1 fibers per milliliter of air, which is over 4 hours period of sampling. And then we have the 0.6 fibers per milliliter of air. This is a short-term exposure limit, and it's related to 10 minutes duration of sampling. Environmental sampling. So we have a few activities that are actually not directly covered in our legislation by limits. So I'm suggesting here for test controls and RPE suitability, we should compare to our occupational exposure limit. While if you measure leakage or background sampling, that should be compared to the clearance indicator, which is a 0.01 fibers per milliliter of air. And then of course we've got the clearance to confirm that an area is suitable for reoccupation after we've done asbestos work. As you can see in the picture, we need to measure that the asbestos levels are acceptable. And what type of equipment we're using for asbestos sampling. So obviously we need a pump, a sampling pump. And then we use a filter, which is a mixed cellulose ester filters. It's got a particular diameter and pore size. We have an open face filter holder and a cowl, electrically conducting cowl, and a tubing. So in the picture you can see those pieces of equipment, the filter holder, the personal sampling pump, and we can also see the high volume sampling pump, which is used for environmental sampling. So I'm not going to go into too much detail, but this table is showing us the sampling flow rates, minimum volumes that is required, minimum of number of graticules to be counted. This is for the analysis of asbestos fibers, how many fields we count on each filter, and also the corresponding airborne concentrations at the level of quantification. This means basically that we cannot report concentrations which are lower than those values. If we sampling at the flow rate and the minimum volume, which is and we counting that number of graticules, we can't really go lower with the phase contrast microscopy method that we're using for analysis. So this is something to bear in mind. Asbestos enclosure. What is an asbestos enclosure? This is basically a structure that we put around a source of asbestos that we want to remove. For example, we have an insulation around the boiler. This is a high risk, probably type 3 type of work, high risk friable asbestos that we need to remove. And so we build an enclosure prevent a contamination of the environment while we removing the asbestos. So in the HSG 248, there are some guidelines regarding the number of samples that we should be taking depending on the size of the area and the volume of that enclosure. I haven't really shown all the values, just picked up a few one to just for you to get an idea what is it about. But as you can see, of course, the larger the area, the more samples we need to take. Okay, so let's talk a little bit about bulk asbestos sampling. And why do we do bulk asbestos sampling? So to determine whether a material contains asbestos. Also, if we want to know what type of asbestos fibers we have in the asbestos containing material. As you know, we have 3 different types that were commercially used, and the risk of them is different. And of course, complying with the regulation with regards to identifying, assessing, labeling, and recording asbestos containing materials, and this is all about creating our inventory. And at the bottom of my slide, you can see a few typical sort of asbestos containing materials in a building. What do we need to sample for bulk? So we need something to wet the material, spray bottle and detergent. Core cutter, what is a core cutter is, you can see it in my picture at the bottom. It's basically if we want to have the full depth of the material, we want to take a sample. Sometimes there are layers within a material. For example, an insulation material, the outer layer can be non-asbestos, but then there is a bottom layer underneath which contains asbestos. So we need to take a full sample of the material, knife, scraper, pliers, all these are helpful. Plastic bags, bottles, sealable containers, this is to place our samples. We need to capture the data about our samples. Camera is very useful. Otherwise, we won't be able to take these nice pictures. So sometimes we get, not sometimes, quite often we get people wanting us to analyze asbestos in bulk sample, and we are doing this at the NIOH pathology department. Unfortunately, we're not in a position to go out to different parts of the country and take those bulk samples. So we try to assist people to take those samples in a safe manner. And the most important thing about taking a bulk sample is really to try and minimize as much as possible the creation of dust. This is why we wet the material beforehand. As I mentioned, we're trying to take a representative sample, but this is always, you know, on the one hand, we want to take many samples perhaps, but then we want to cause least damage possible. So there is a compromise here that we need to make. The samples don't have to be big. I would say less than 500 grams would be enough. Diameter, let's say 2-3 centimeters should be sufficient. We need to use the appropriate PPE, of course. A dust mask would be a minimum. Avoiding cross-contamination. So when we take a few samples, we need to be careful about not cross-contaminating our samples. We need to clean our equipment after taking each sample, decontaminate, sanitize to make sure that we don't contaminate. Placing the sample into suitable sealable container. And of course, the sampling points should be repaired or sealed as much as we can. We usually demarcate the positions that we took the samples from for future reference. And then the samples must be uniquely identified with unique numbers. Okay, so we really can't speak about sampling without saying, we're not saying anything about the analysis of our samples. So we have basically 3 methods for asbestos analysis. And this is the polarized light microscopy, which is used for particularly bulk material, fiber identification in bulk materials. It's a qualitative method, and it's a relatively, I'm saying relatively because those microscopes cost a lot of money, but relatively low cost. And it's a quick method. It works on colors. So we immerse our fibers in a special liquid with a refractive index, particular refractive index, and that show the different colors are indicative of the type of asbestos that we're dealing with. And then we have the Rolls Royce of asbestos analysis, which is the electron microscopy method. It's very, very sensitive. It can go down to molecules. Electron microscopy analysis can actually analyze the material based on the chemical composition of that material. So we can 100% know what we're looking at to a very, very fine details. It's very expensive equipment. We are fortunate enough at the NIOH to have one like that. Of course, it requires a lot of training. It's used for environmental and research studies, and also to, like I said, we're getting samples for bulk analysis, so we would use the electron microscopy for that as well. Then we have the phase contrast microscopy. It's probably the most popular method. It's less expensive than the electron microscopy, more affordable by laboratories, relatively quick and regulated. In other words, our regulations now refer to the HSG 248, and the HSG 248 is there is an appendix with regards to analysis using phase contrast microscopy. So for typical exposure assessment, we would use phase contrast microscopy. The big setback of this method is that we really we identify asbestos fibers based on their dimensions and shape, and not like the electron microscopy based on their composition. So one can never be 100% sure that what we're actually looking at is asbestos fiber. It can be other types of fibers. But it's a fairly accurate and, like I said, affordable method. Okay, I think I'm done. So this is us. You're welcome to email me with any questions or contact us, the NIOH, if we have any queries regarding asbestos. We're very happy to assist. Thanks very much.
Thank you very much for that, Gabby. My colleague in the National Institute for occupational health, occupational hygiene section. And I am quite pleased by the interrelatedness and complementarity of the complementing presentations that have happened thus far. And I'm sure that our attendees have a number of questions that they may want us to deal with before we close the session, and have the Chief Inspector, that is Mr. Tibozana, do the closing remarks on the conclusion of this particular launch. So thus far, we've had both a welcoming address by the Inspector General, the moving towards an asbestos risk-free society by the Director General, Mr. Tobile Lamati, the background to asbestos abatement regulations by Ms. Bolel Wahuna, the Senior Specialist, the very detailed asbestos abatement regulation a rundown by Ms. Elise Lawrence, the specialist there, and then complemented now by Gabby's input on asbestos sampling. So I'm going to ask all of our panelists and presenters just to be ready to open their microphones and video if they so prefer. We do have some questions that may need to be addressed, and I'm going to just randomly select one. Okay, so one of the first questions there, Gabby, if you could just unshare your presentation, it'd be appreciated. Thank you very much. Okay, so there's a question by Vernon Mini. How would one go about encapsulating or painting asbestos-containing materials without any surface preparation? So I'm going to allow any of our colleagues, Gabby, are you ready to answer that one?
I think it's a difficult one actually to answer. I'm not sort of a building contractor or anything like that, but I think like Elise also said earlier on, if you can just take a paintbrush and paint something, that's fine. But I think in most cases, when you do this kind of work, you actually have to have some kind of preparation of the area. So it's a tricky question. Yes, that's as far as I can say.
Thank you, Gabby. Are there any other comments from our panelists? Elise, I see your microphone is open. Please proceed.
Yes, thank you, Ashraf. Yes, just in support of what Gabby said, that's absolutely correct. Most of the time, before we can paint or encapsulate, there is some surface preparation needed. So unfortunately, that time period, that window has now closed for that kind of work to be done. So if you cannot do the encapsulation of the painting without any surface preparation, then that is no longer an option on the table for you. Then other options of dealing with the asbestos material needs to be considered and needs to be then implemented in your management plan. So as I said this morning, we're all going to have to do things differently now. We cannot just continue as we have been for the past 19 years. It's time now that we take this seriously and start moving away from the asbestos risk in this country. Thank you.
Thank you for that, Gabby and Elise. I'm not sure if there's any other further comments on that one. In the meantime, I'm going to move on to the next question, and it's by Cara Belstead. Some question, a reference to another person's question. Can we, in our reports, justify not doing clearance air monitoring in the instances covered in the HSG 248, or should we always do clearance air monitoring? And that's Cara's question. I'm going to ask any of the panelists to deal with that. Please just indicate if you want to respond to that. Elise?
Can I go?
Gabby?
Yeah, okay, Gabby, you go first.
Elise, no, that's fine.
Gabby?
Elise? Yeah, no, I just want to say, and I think Elise will back me up on that one, that any time that you do type 2 or 3 asbestos work, after you've completed this work, you have to do clearance sampling. That's my understanding, but Elise, correct me if I'm wrong.
No, that's absolutely right, Gabby. But remember that clearance certification is not only clearance sampling. there are other activities also required for making a thorough visual check that you don't see pieces of asbestos material lying around. So if the AIA, and I doubt very many of them would feel comfortable, but if the AIA feel comfortable in declaring, certifying an area clear after type 2 and type 3 asbestos work without doing clearance monitoring, they can justify that in a report. But as I say, I mean, their accreditation with SANAS as well as the department depends on that in doing it correctly. So they will put their reputation on the line if they then provide clearance certification without doing clearance sampling. But I guess there might be some very few cases where just a visual check and previous samples during the work would justify not taking clearance sampling. But as I say, this is not the only aspect that will lead you to actually certifying any area clear.
Thank you. Bulelwa, I saw you earlier unmuting or indicating is there something to add to this, or could I go for the next question?
No, can go for the next question. Elise has responded.
Thank you very much for that. So if I could just get to the right box, multitasking here. And so the next question is regarding Regulation 19.6b, references Chapter 9 of the HSG 248 and decon facilities. I'm not sure if it's already covered perhaps earlier, but the HSG 248 relates mainly to the protection of the analyst AIA and not the removal contractor. Am I correct that the intention of the regulation is to extend the Chapter 9 requirements to the removal contractor employees as well? Just want to make sure, as some contractors will kick against the requirement and point out that Chapter 9 is not for them. Thanks, and that came from Brett Williams. Over to our panel. Okay.
I was hoping that Gabi would grab this one again, because he's got more knowledge about the HSG 248 than I do. But yes, I think the idea behind this, including this method in the regulation, is for us not to repeat the requirements in there. But if there's something that we need to look into closely, at the end of the day, if you, with these kind of questions, consider what would be the best for protecting everybody, and that will then be a requirement. And then the enforcement of the regulation is the responsibility of the department. So leave it to us to sort it out.
Thanks for that, Elise. Gabby, do you want to add anything there?
And I agree with what Elise said. I think it's correct that the HSG 248 really is written from the, let's say, from the perspective of the analyst, of the one who's going and doing the supervision and the monitoring and all that. But I don't think our regulations is really a copy of the HSG 248. And I feel there is enough protection in our regulations, regulation for both the, the analyst and the contractor, the removal contractor. So that's the way I understand it.
Thank you very much for that, Gabby. And so I invite any of the panelists and presenters, if they want to add something, just to step in there. We do have approximately about another, let me see, yeah, we've got quite a few minutes still, about 10 minutes for this Q&A. I'm going to move on to the next one. This is from Anonymous. And Anonymous is saying, greeting, etc. Thank you for the detailed regulation. Just one comment. Why did we not consider including this SANS, the SANS Hazard Symbolic Safety Sign WW13, into the new Asbestos Abatement Regulation as part of Annexure A? This is a very well-known and commonly used sign in South Africa. May you kindly provide more information on the new labels, signs, for example, sign ID, source, UN, Orange Book, etc. Will the employer be required to replace the old WW13 hazard sign on the existing buildings containing ACM with a new sign/label? And is there a time frame involved from Anonymous? Handing over to our panel.
Thank you, Ashraf. If you look at Annexure 1, you will see that there are basically two options with regards to signs. So the one is the asbestos warning sign, and then the other is the asbestos warning label. So the label specifically incorporates two pictograms from the globally harmonized system for classification and labeling of chemicals, the HSG, that the question is referring to. So we try to find a midway between moving to what is internationally now used according to the JHS, and then also what is commonly known and understood in South Africa. So that is how we came up with these two symbols. And I would think that we can use them interchangeably until things change. And obviously what is most important here is that awareness training would be needed for everybody to be aware of what these symbols and these signs that are going to appear over the next 17 months on our buildings and in our buildings, what they mean. Because that is what is important, not actually the picture that appears there, but that everybody knows what that means and understands the implication of these labels that we are providing there.
Thank you, Elise. Any further comments? Otherwise, I'm going to move to the next question. Okay, so Brett has had a second question here, Brett Williams. And the question is, will surface preparation and painting of roof sheets be considered type 3 based on the definitions of type 1 and type 2? I do know that our presenters have touched on this whole question of surface preparation and the complications there, and I think prohibitions. So I'm going to ask our panelists to answer that question for you, Brett, in terms of your question regarding the categories type 3, type 1 and type 2, and if it's applicable to surface preparation or just the question of painting. Elise, do you want to start on that one, or Gabby?
Yes, thank you. So as I said, when I started with the three definitions that I dealt with at the beginning of my presentation, is that each one of those definitions for the type 1, type 2 and type 3 deals with the kind of material that that work is applicable to, as well as what you can do to that material. So you will see that type 3 work then deals with a specific type of material. And if you look, there are definitions within the definitions. So the term asbestos containing material is defined, and asbestos is defined. So as type 3 asbestos work is limited to those types of materials. And no, surface preparation is not allowed on those types of materials, and also the asbestos cement products dealt with in type 2 work, once again, the surface preparation is not allowed for that type of material. So the definitions were separated with regards to the type of material and actually what you can do on those types of materials. Hope that clarifies the matter.
Thanks, Elise. I'm not sure if any other colleague wants to add to that. Otherwise, I'm moving on to Ken Annandale. And Ken asks, could you please provide the relevant South African qualifications authority, that's SACWA unit standards that must be followed to ensure competency as per, and he quotes, the competent person. And I think he gives the definition means a person who has the required knowledge, training and experience, and where applicable qualifications specific to asbestos work, where appropriate qualifications and trainings are registered in terms of National Qualifications Framework Act, the NQF Act of 2008, would not have been able to find, we have not been able to find a unique SACWA unit standard. Are you able to assist? Okay, so I'm not sure, Elise, if this and Bulewa and colleagues, if this is something that we should perhaps defer and indicate to Ken that we can get back to him after the post-webinar. because it clearly involves the skills development structures and bodies. Bulelwa?
Thanks, Ashraf. We'll defer that question because, like we're indicating, it's part of skills development program, and some of the asbestos training information is embedded on other unit standards with SAQA, and SAQA has got very specific requirements when it comes to unit standards. So we'll defer that one when we respond. We provide because they are also asking for the QA questions to be provided with the information webinar. We can also provide that response. Thank you.
Thank you for that, Bulelwa. And then there's a question by, I think it's Professor David Rees, and I think he refers to Regulation 24C as well with regard to households. Now, it's a bit of a cryptic question. So to the colleagues on the panel, is there any specific importance and relevance of Regulation 24C regarding the implications for households? Colleagues? Okay, there's no immediate response to that. Elise?
I was just paging here.
Okay, no problem. Yeah,
24C.
24C, and the specific question relates to, my understanding is the implications for households.
Okay, so maybe just to inform everybody, 24 is then prohibitions. So it reads, no person may temporarily store any asbestos or asbestos-containing materials for longer than 3 months after the completion of asbestos work. So obviously, yes, if asbestos work has been performed at a private home, and the choice is made to store it temporarily there until enough is accumulated to make the trip worthwhile, then yes, that will apply to a household.
Thank you very much for that, Elise. And I'm sure Prof. Rees can take the opportunity to follow up if there's any follow-up you would like to do there. Anonymous attendee, should the new asbestos abatement regulation training, which has an initial contact time of 8 hours now, contain practical training as well now on the removal of asbestos containing products, or is the theory, I guess that is sufficient or efficient is what the questionnaire typed. So again, it comes to the question of the appropriateness of training given the new asbestos abatement regulation provisions. Any comments on that, general, for now, or do we just delay that, Elise?
Yes, so basically the regulation is clear that 8-hour contact session, the intent is that both theoretical and practical information be shared with the attendings of that training. But keeping in mind, the focus of this training is to train workers on how to do this work safely. So the practical aspect of the training, I would think, would include illustrating how to remove asbestos materials safely. And if you know, and you should know as a training provider exactly what kind of work the contractor will be doing, then you can tailor-make that practical experience specifically for them to know how to remove asbestos roof sheets maybe safely, or if it is a lagging material that they are removing, to customize that practical experience for them to get hands-on experience. And obviously included in there is the personal protective equipment and respirators. So a demonstration, a practical demonstration of how to put on a mask or how to safely remove a mask without contaminating your hands. So that is the kind of things that we are looking for when it comes to practical, including in the training. Thank you.
Thank you, Elise. Any further additions to that, colleagues? Otherwise, I'll move on. Gabby, are you okay?
Yes, I think it's crucial that you have practical training for contractors. The theory should actually be the smaller part of the training, while the practical training should be the bulk of it. That's what I would say. It's very, very important.
Thank you, Gabby. And so the next question is by Irene Jacobs, and I'm just quickly dealing with the unanswered questions. It appears to be growing slightly, and we hope to get through it all. I've got to, in fact, come to a conclusion, I think, with Irene's question, and bring in the Chief Inspector, Mr. Tibozana. So Irene, this is the last question. There are some other unanswered questions. Please do not add any more questions to the question and answer box. We are going to encourage you to contact the colleagues at the Department of Employment Labour who's been assigned to deal with any follow-up questions you may have post this particular webinar, and I've posted their contact details in the chat, and that's Mr. Bongi Kumalo and Ms. Patience Gubeni. And so, Irene, where can I source a training vendor that offers the right training for a person to be deemed a competent person? Is there a very quick, short answer to that question, colleagues? Okay, so I'm going to encourage you, Irene, then to contact that's Mr. Kumano and Ms. Gubeni at their email addresses and their telephone, their landline telephone numbers that I've provided in the box. I'm going to repost it in the chat box, and I'm going to conclude our question and answer session at this point in time and say many thanks to our presenters and panelists for assisting in answering those questions we could manage in this short session. And at this point, I have the pleasure of inviting Mr. Tibozana, the Chief Inspector of the Department of Employment and Labour, to please engage with the closing remarks and thank you. I can see just to check, no, that's Gabby's picture, apologies. Just to check with you, Mr. Zana, if you have your video and audio that you can share with us. And I am just checking also if you have an actual presentation to prepare. In the meantime, whilst we are just doing that transition, I'm going to quickly share again on the chat box the contact details of the colleagues that you need to get in touch with regard to any further questions you have post this particular launch webinar. And I will also be sharing the other details for you to be able to download the actual regulations, as well as the video on the YouTube channel that the Department of Employment and Labour has prepared on the launch of the new Asbestos Abatement Regulations. So just to check if Mr. Tibozana is with us. Oh yes, apologies, I can see your microphone is open. Can I hand over to you, Mr. Zana? You are too quiet. Sorry, you're too low, sir. Your audio is not audible.
Okay, I'll increase my volume. Is that better?
That's way better. Thank you very much. I hand over to you.
Ashraf, thank you very much. As a Department of Employment and Labour, of course, we always do appreciate the interaction with the NIOH and, of course, our clients. And in this particular case, this is obviously a big wow for us. Introducing the regulations as we have on asbestos abatement today. And I think you'll find that the regulations that we have presented today comes with quite an interesting package, but we'll touch on that in a moment. So I'd like to thank the Director General, Ms. Plamati, and the Inspector General, Ms. Moirwa, for joining us today and for taking the time off to interact with us at this level. The NIH, of course, and the senior management team of the NIH, I would like to appreciate the fact that that they're always willing to work with us and to ensure that our clients are fully informed of what's happening. Technical Committee 7, of course, they have done quite a lot of work, and the asbestos group under them, the work group, has done quite a bit of work around this regulation, and I think it's quite exciting. Now, with every regulation, of course, there are sometimes unintended consequences, and we are looking forward to interacting further as time goes on. The Advisory Council, of course, has been instrumental in making sure that we do have a regulation that has come out and has been presented. Of course, under the leadership of Ms. Huna, her team has worked quite spuriously to ensure that we do have regulations that are seeing the light of day in the shortest time possible. And for that, I want to thank her and the team, of course. And during the public comment phase, as was touched on early on, we try and sort out many of the issues that could possibly present itself as a problem. And in this case, people have taken the time to actually make sure that the regulation is refined to the extent that we anticipate. So we obviously appreciate that. So what you'll find, the package then that has been put together, you've heard early on of the video that has been put out or released. That is the first time that we have one coming out with a regulation. The following information is now available with the Asbestos Abatement Regulations. Of course, the regulation itself, explanatory notes to the Asbestos Abatement Regulations, frequently asked questions relating to the asbestos issue, and some of the questions raised today will of course be supplementary to that document. So we'll obviously build up over time as we also learn as things take place around the regulation. A list of registered asbestos contractors. This we have been publishing from time to time online to ensure that clients have access. A list of approved inspection authorities, and then of course the criteria of applications to register as an asbestos contractor. Now, Ashraf, you can see that there's quite a lot of work that's been done, and we do believe that any client out there, those who want to make use of services of contractors and so on, that you'll see that there's no running around looking. They can visit our website at www.labour.gov.za and they'll have access to the information. Otherwise, as you've correctly stated, Miss Kumalo, Bongi Kumalo, she's available on the number given, as well as Miss Ngubeni. So the Department of Employment and Labour has provided our clients with sufficient information to be able to do this work efficiently and effectively. With that, I thank you for taking the time off today to join us as a partner to make sure that we are able to present this important regulation today. And then also to the team that you work with. Thank you for that as well. With that, I'd like to declare the session from our side closed. Thank you, Ashraf.
Thank you very much. That's the Chief Inspector, Mr. Tibor Zana. Mr. Zana, it's a pleasure on behalf of the Executive Director, Acting Dr. Muzi Mzimkulu, Dr. Mzimkulu Zungu. We thank you for the opportunity to partner with you as the NIH with the Department of Employment and Labour. And quite clearly, this particular regulation is an important groundbreaking one in addressing quite a number of important elements. And I've just watched the chat box, and it'll be great for you just to have a quick look at some of the comments there. Both the congratulations to the Department of Employment and Labour, as well as to the actual presenters in terms of the value of the content that they've offered. I have checked with your colleague Elise Lawrence, and she has indicated the Department of Employment and Labour is making the presentations available to be shared with the attendees who've also asked for that to be shared. So thank you very much for you and your team, the Director General, the Inspector General, as well as the senior specialists and specialists, and obviously my colleague, Mr. Gabby Mazan, in the occupational hygiene section of the NIH. It is always a pleasure to partner with you, Mr. Zana. And at this point, from my side, a big thanks to my colleague, the manager of the IT department here at the NIH, and that is Mr. Ola, Dr. Ola, apologies. in the IT section, and his team who had assisted prior to today in some of the preparation. And quite clearly, they are the head of our information services section, Ms. Angel Mzoneli, and the head of the communication sections, Ms. Shanaz Hampson. And they've been critical in getting this particular invitation out via the different NIOH mailing list. And that is over 35,000 people who've attended our COVID-19 Zoom webinar since the 9th of March. And so it's with great pleasure and with great pride on behalf of the NIOH that we've had the opportunity to partner with you, sir. So on that point, we are going to just quickly again share in conclusion all those contact details for you who have not yet, screen grab them or capture them and copy them off our chat. Thank you very much, Mr. Tibozana, and obviously to Mr. Tobile Lamati. And my big apologies. Quite clearly, your two colleagues taking correspondence after the webinar are both ladies and females, and I have confused one of their genders in calling the person a male. On that point, thank you very much to you, sir. Clearly, people, if you've not yet downloaded the asbestos regulations, please do so. The link is in the chat box, as well as the slideshow that's going to be on in a moment. And with that, with exactly 3 minutes short of our closing time, Mr. Zana, we say thank you very much, everybody. We've had over 660 people attending, and we've had almost 1,200 people actually registering. And that's quite a good attendance record. So thank you very much. On that point, I'm going to share the particular slide that deals with the background music as well.